Good morning and welcome to Flash Briefings by Manning Fulton. Today's topics is COVID-19's impact on commercial lease disputes and evictions. It's the fourth of Manning Fulton's Flash Briefings, designed to provide you with key legal insights in support of your business objectives. My name is Alan Dickinson, the Director of Client Relations here at Manning Fulton, and I'm very glad you could join us this morning. It's my pleasure to introduce my colleagues William Smith, Whitfield Gibson, and Rob Shields, three exceptional litigators who will be leading today's session. One housekeeping note, you will have the opportunity to submit questions this morning by typing the questions into the questions pane of the webinar's control panel. And we hope you'll take advantage of that during the presentation. If we are unable to address your question during the session, one of this morning's panelists will contact you directly following the presentation to make sure your questions are answered. And with that, I turn it over to Whitfield.
Good morning, everyone. I want to give you a brief overview of what we intend to cover today, time permitting. I'm going to speak first to the general timeline and procedure for summary ejectment proceeding to remove a tenant, both residential tenants or commercial tenants, and how that process generally goes under normal times. And the timeline that you can expect. William Smith will then talk about some of the differences that have happened because of the COVID restrictions, including some of the moratoriums by the governor. Rob Shields and I then will discuss both potential contract defenses to any summary ejectment or lease action, as well as some of the potential common law defenses we might see. And then William Smith will discuss the bankruptcy implications that we have found, at least as we have begun doing some of these summary ejectment proceedings. So with that, let me start by giving you a rough general timeline of the summary ejectment procedures as we've seen them for both residential and commercial tenants. As most of you likely know, the summary ejectment proceeding is the judicial way to remove a tenant from the property. That can be done for basically three reasons. The most common is the failure to pay rent. Any tenant is required to pay rent. If they fail to do so, then summary ejectment proceedings can be initiated. The second would be a violation of the lease agreement where eviction is one of the potential remedies. If they are operating the business inappropriately, if they fail to pay CAM charges and stuff like that, those may also be a violation of the lease provision, which would entitle you to eviction. The third would be if the lease has expired and the tenant refuses to leave, they are holding over, that sort of thing. Summary ejectment would be the appropriate procedure to remove those tenants. Generally, we recommend using the summary ejectment procedure rather than some of the more common self-help remedies, or even some of the contractual remedies that may be in commercial leases, because with a self-help remedy, there is the chance that if the tenant refuses or in any way objects to the removal, then the landlord could be responsible for what is called breaching the peace and could be liable for damages as a result of that. Going through the summary ejectment procedure eliminates any possibility of a breach of peace argument. And so therefore, we recommend doing this. And the procedure is not that different and is purposely meant to be somewhat quick rather than a breach of lease civil lawsuit. To start off with, generally what a landlord would need to do is send a notice of default at whatever point in time per the lease agreement that the tenant has failed to pay rent or has otherwise breached any of those lease provisions. You would need to send a notice of default and, if necessary under the lease, a right to cure and wait the appropriate time period. You are also entitled to, at that point in time, initiate the summary ejectment proceedings. The way you would do that is there is a form complaint, a summary ejectment complaint that you would file, and you would have to serve it and generally have to file it and have a trial date approximately 10 days after the date of filing. And this is important because, again, the purpose of the summary ejectment procedure is to remove tenants quickly. Once you have filed the complaint, generally we recommend sheriff's service. They can post to the property. They have to do so at least 2 business days prior to the date of the hearing. If you have a property manager, they can also serve by posting on the property. You can also, if it's a business, serve on certified mail, return receipt requested, but you would have to be able to have someone, some proof of service if you're doing it that way. If you have the sheriff posted on the property, they will return the return of service. If you have a property manager who does so, then they will need to fill out an affidavit of service or will need to testify that they did serve the property by posting. Generally, in the complaint for summary ejectment, especially in commercial leases, we recommend that you do not fill out and do not request damages, but rather you seek summary ejectment for possession only. The reason for that is in magistrate court, where a summary ejectment procedure is initially heard, the damages are capped. Furthermore, if you regain possession of the property after the summary ejectment and find, as many of our clients have, that the tenant has either left the property in disrepair, if they have taken fixtures or other items that they were not allowed to take from the property, those are appropriate damages for any breach of lease provision, but those may not be damages that you would be able to recover in a simple summary ejectment action. And that is why when we file summary ejectments, we always, or almost always, reserve damages and are seeking possession only to recover possession of the property. So that helps because you don't want to limit yourself on damages. You want to make sure that if you go back in, you might be able to apply any security deposit, but if there's anything outstanding, including the back due rent, late fees and stuff like that, that you would normally be able to recover underneath a breach of lease agreement, breach of contract for the breach of lease, you would be able to recover that in a separate action. You may not be able to recover that underneath the summary ejectment action with the magistrate. So that's why we recommend holding off on those damages until later. So once you have been scheduled for a hearing, as I said, generally the courts are pretty good about trying to schedule that 10 to 14 days after filing. Once you have that and have service or proof of service, you will need to make sure that you have someone who can testify to the fact that it was a valid lease, and usually presenting that and just having a property manager, or it can be anyone associated with the property who has reviewed the business records can testify to these things. But you would need to show that it is a valid lease agreement. And for instance, if it is a summary ejectment action on the basis of failure to pay rent, you'll need to have someone who can testify that the rent has remained unpaid for whatever the time period was. If it is just a month, if it had been a couple of months, they will need to be able to testify to it. If you've got a rent roll or some sort of accounting, you can present that into evidence as well. Again, that would not be to prove damages in this case, but merely to prove the breach of the lease agreement for failing to pay rent. Once you have that and have that person, the property manager, someone associated with the landlord present, generally in a lot of these cases, the tenant refuses to show, in which case we can make a motion for judgment on the pleadings and be granted possession. If not, you will have to swear in the witness and ask questions about the validity of the lease, the payment of rent. And again, if this is one of those actions where it is for some non-monetary breach, you're going to have someone who can present evidence of that. If there was inappropriate activity, if you find that there's been some disruption, you're going to have to be able to present evidence of that. And then the tenant will have the ability to respond. There's a couple of specific things necessary for residential evictions. There's some extra paperwork you have to file for residential tenants. A civil serviceman's affidavit needs to be filed. We generally file them even for commercial tenants. It essentially just says that the tenant is not in active duty, is not active duty military, and the law requires that you cannot evict someone who is on active duty and is out of the country or serving. So you would have to have a civil serviceman's affidavit. We generally provide them as well or have them on hand, even for commercial tenants. The law doesn't require, some of the magistrate judges prefer to have it. The affidavit itself is fairly easy for commercial tenants because the reason you put it is it's unnecessary because the tenant themselves are a commercial client of some sort. and that would alleviate that need. But we have seen some magistrate judges require it even when the law does not necessarily require it, and it's a fairly easy step. So once you go through that process and have the hearing, and the judge then, well, let me start here. The tender of rent can be a defense, and I know Rob and I will talk later about some additional defenses that we believe tenants may try to bring up with the pandemic situation ongoing. But the tender of rent itself can be a defense if you have not terminated the lease prior to the date of the hearing. So you just need to be aware that if they show up with the entire amount, late fees, and otherwise, you can have that will be a grounds for a dismissal. It does mean that as the commercial landlord, you are getting all of the rent and court costs, but it does likely mean that they will not be required to vacate the property. So assuming that you are given a judgment for possession of the property, there's a couple of other ways that the tenants may be able to stay some additional time before you can remove them from the property. They are allowed 10 days to file a notice of appeal to the district court. Generally with the notice of appeal, during that pendency, the landlord cannot do anything to take over possession of the property unless the tenant has abandoned completely. But during that time period, they have the ability to file an appeal, generally post a bond. And once they have filed an appeal to district court, they are required to pay the monthly rent during the pendency of the appeal to the clerk's office. If they fail to do so at any point in time, you are allowed to get a writ of possession from the sheriff and remove them from the property. And that is important because occasionally if they make an appeal to district court, they're generally tenants are trying to buy some additional time, move out of the property, find additional spaces, that sort of thing. However, if they ever do fail to pay rent during the pendency of the district court appeal, you are entitled to a writ of possession from the sheriff. The appeal to the district court operates very similarly. You don't need to file anything additionally. The complaint in the magistrate court will act as the complaint in the district court, but the appeal itself is de novo. So should it be called for hearing, you would be required to present the same evidence that you did, call the same witness to testify to the validity of the lease and the whatever that breach may be, whether it's a failure to pay rent, which again is much easier, or any breach of the lease provision or that the tenant is holding over in that case. Once you have a judgment in the district court, any appeal from there must go to the Court of Appeals and follow a much stricter procedure for doing so, filing the notice of appeal, that sort of thing. Again, during this entire pendency, they still have to be paying rent. If they do not file any appeal, if they fail to pay rent to the clerk's office, or if they inappropriately file any of the appeal paperwork with the Court of Appeals, you would then be entitled to get a dismissal of the appeal action and possession of the property. And again, we would have any damages come at a later date in a separate breach of lease action once you've been able to take over possession of the property. So that is a general overview and timeline of sort of the longest summary ejectment procedure that we believe you might see. Some of those have changed, and some of those timelines and some of the requirements have changed due to the pandemic. And to discuss that, I'm going to introduce William Smith.
Good morning. Thanks to you folks out there for being with us. I'm going to talk a little bit, as Whitfield said, about state and federal moratorium and restrictions that have been applied. As you know, President Trump has declared a state of emergency back in March, national emergency. Quickly thereafter, the Coronavirus Aid, Relief, and Economic Security Act was put in place. That act did not have any impact on the relationship between residential or between commercial landlords and tenants. However, it did have significant impacts on residential tenants. So despite the title to the program, I'm going to talk mainly about the impact that the federal acts have had on residential evictions, because there really haven't been any on commercial tenants. The CARES Act restrictions sunsetted at the end of August, but they were followed quickly by a joint resolution or a joint order by the Centers for Disease Control and the Department of Health and Human Services, which issued moratoriums that came into effect September 4th and will last through December 31st. Those restrictions made it so landlords or mortgage holders could not evict tenants or residents who provide an affidavit to the landlord and assumably to a magistrate in a summary ejectment proceeding that contains the following 5 facts. Number one, that the tenant or resident has used its best efforts to get government assistance. Number two, that the tenant or resident earns less than $99,000 a year or expects to earn that if an individual, and $198,000 a year if a couple. The third affirmation is that the tenant is unable to pay rent or make payments due to layoffs or work shortage or reduction of hours or medical expenses. The fourth is that the tenant has made its best efforts to make partial rent payments. And the fifth is that the eviction will render the individual homeless or cause him or her to have to live in close quarters with others. The CDC and HHS restriction applies to all landlord-tenant residential situations, not just those backed by federal or where properties are backed by federal mortgages, which is important. The striking thing, or things that I see from the CDC and HHS orders, are a couple of things. First, it seemed to me, a remarkably high income ceiling, $99,000 per individual renter and $198,000 for couples. That would seem to me to cover a whole lot of the folks who rent, especially in this area. The second thing that jumped out at me was that tenants can take advantage of this, not just for COVID-related work shortages or COVID-related medical expenses. It appears to cover anyone who is unable to pay rent due to medical issues with the family. This is not really an economic relief statute. It's more of a statute to stop the spread of AIDS, as is evidenced, or of the COVID virus, as is evidenced by the provision that it's likely the magistrate would have to make a finding that it would make people homeless or cause them to live in a congregate situation. So obviously the idea behind this is to stop the spread of the COVID virus. It does not apply to stop evictions for crimes or other lease defaults. The rent still accrues. The rent and fees are still owed at some point. So one question I have is whether a landlord could sue for rent or seek to recover rent, but not seek to evict during the period of this moratorium. I don't know the answer to that, and that I'm assuming that would be interpreted as we move along. Late fees and penalties and interest may be charged. The CDC and HHS order does not apply to hotels, seasonal rentals, vacation rentals, that type of thing. Some folks have questioned the enforceability of an order governing landlord-tenant relations issued by the CDC and the HHS because they are typically not organizations that get involved in those relations. But the penalties, the stated penalties for violation are steep, up to $250,000 for individuals and up to $500,000 for organizations who violate this. So I would suggest that you don't want to be the test case in this if you have residential tenants and you don't want to push that. See a lawyer before you do anything in that regard. Also, the Federal Housing Financing Agency and HUD have issued or extended a moratorium on foreclosures and evictions for FHA-backed loans that also last through December 31st, 2020. That applies to protect borrowers with federally insured single-family mortgages or residents of those properties. Significantly, it also applies to prevent owners of multifamily properties from evicting folks if the multifamily owner has received forbearance on his federally backed mortgage. So in other words, if you own an apartment house or other facility and you are receiving forbearance from a federally backed loan, you have to pass that on to your tenants. In North Carolina, all of the prohibitions on commercial and residential evictions have expired. The governor did issue an executive order back in the spring, executive order number 142, that prohibited all evictions for non-payment of rent during a period from May 30th through June 20th. That has had a lingering effect that I think does impact commercial tenant-landlord relationships. That order provides that commercial tenants must be provided the opportunity to make reasonable payment arrangements to pay off over at least 6 months any rent that came due during the effective period. The effective period is May 30th through June 20th. So I interpret that to mean June rent. You've got to give even commercial tenants the right to make arrangements to pay June rent over a 6-month period. How does that impact your relationship with a commercial tenant? Obviously, if the tenant, if you have a current tenant who has only missed the June rent payment, I think you have to give that tenant that opportunity to pay that off before you would proceed with eviction or collection. If you have a tenant who has missed 6 months rent or a longer period of rent that includes this June window, I think you have to be careful and carve that out when you send demand letters and when you file your summary ejectment complaint. In other words, if you send a demand letter that doesn't give them the opportunity to spread that June rent over time, I think that could give the tenant a technical argument at a summary ejectment hearing. And if you include that rent as part of the default in your pleading, I think that could also give the tenant a technical reason to at least delay your summary ejectment proceeding. I think magistrates are going to err on the side of caution in this, and I think unless you have your ducks in a row, you're likely to have your case dismissed or put off. Justice Beasley with the Supreme Court has also issued or did issue a stay of all summary ejectment proceedings. But that has ended July 21st. The only lingering effect of that is that there is a requirement that a affidavit called a CARES Act affidavit be filed and served with any summary ejectment complaint. Now, the CARES Act affidavit is, if you read it, it's there basically to identify residential properties that are subject to these federal loans. But as I read the rule, you must prepare that affidavit and file that affidavit, even if it really doesn't have any application to your premises, with your summary ejectment action, even a commercial summary ejectment action. So if you don't do that, you're likely to have your case dismissed and have to go back and fix that. So with that, I will kick it over to Rob, who's going to talk about force majeure provisions in leases.
Good morning. Thank you for joining us. We really appreciate you sharing your time with us this morning. The COVID-19 pandemic has brought a great deal of uncertainty to commercial landlords and tenants, particularly with regard to the impact of the pandemic on existing leases and other contracts. Parties with contracts that contain force majeure provisions are left wondering whether the current pandemic qualifies as a force majeure. And I'm going to explain what that term means. That's a provision in a commercial lease that excuses performance by the tenant based on certain qualifying events. That might be an act of God. It might be adverse governmental actions. The good news, if you're a landlord out there, is courts tend to interpret these force majeure clauses very, very narrowly, which is great news, again, if you're a landlord. I want to share with you, just to give you an example of that, a few cases prior to COVID. There's very few cases in North Carolina that interpret these types of force majeure provisions. One interesting case is out of Charlotte in 2018. It involved the Charlotte Law School there, which for a variety of reasons, they lost their license to function as a law school. They had a force majeure provision in their commercial lease that excused them from performance for acts of God, regulations or restrictions, or the inability to obtain a government permit. So on its face, you would think, well, that looks like a pretty clear excuse for the tenant not to perform under the lease. But the court strictly construed the lease and found that that force majeure clause only applied to financial obligations other than rent, which is a very strict interpretation in favor of the landlord. And the bottom line is that the School of Law had to continue to pay rent. Since COVID, we really haven't had any cases in North Carolina interpreting, or for our courts are interpreting these types of force majeure provisions. There are a couple of cases around the country that I thought I'd give you a brief synopsis of. There's a case out of Illinois that involved a restaurant in a shopping center. And that force majeure provision provided they didn't have to pay rent if their obligations were delayed or retarded or hindered by governmental laws, governmental action or inaction or orders of government. And the governor in that state had shut down restaurants. So the restaurants said that executive order should have excused them from performance or for payment of rent under the lease. But the court again strictly construed it, and basically because the restaurant had continued to serve people off-site, the court's bottom line ruling was it would reduce the rent, but only pro rata based on the sales that the restaurant brought in. Again, a very strict interpretation of that provision in favor of the landlord. And the other case I'll mention is from Florida. That dealt with the tenant Kirkland Stores. They had a 6-year lease, and because of the government shutdown, they were unable to do business at all. And they asked the court for the remedy of not having to pay rent. And the court again, in sort of a puzzling decision, ruled in favor of the landlord and said that Kirkland had failed to prove adequately that its non-payment of rent was brought about by governmental action, which again is a little puzzling, because if the governor issues an executive order shutting down restaurants or businesses like Kirkland's, they can't pay rent. But again, it shows you how strictly courts construe these provisions, which again is good news for landlord. So these cases really illustrate that parties to a contract with a force majeure clause who can no longer perform their obligations must demonstrate that the governmental action stemming from the pandemic is directly implicated by the language of the contract. So like everything else in a lease, it all goes back to what your force majeure provision says, and parties must demonstrate that a COVID event has resulted in or directly led to the inability to perform. So again, from a landlord's perspective, the limited case law that we have shows that the courts strictly construe these provisions, again, in favor of the landlord. And with that, I'll turn it over to Whitfield to share with you some of the common law defenses from the case law with respect to performance by a tenant.
Thank you, Rob. Yeah, there are two others, and candidly, the courts in North Carolina yet heard cases on even these common law defenses as it relates to an eviction or breach of contract action on the lease provision in the time of the pandemic and COVID. But there are two other things that I think an enterprising tenant attorney may try as a defense and common law defense outside of the terms of the contract. One would be the defense of impossibility, and the second would be the frustration of purpose or commercial frustration doctrine. Those tend to go hand in hand and are very similar to what Rob Shields talked about on the force majeure. Generally, the impossibility is when performance is rendered impossible by the law, provided that the promisor is not at fault and has not assumed the risk of performing. And specifically, the case law has held that government actions may be a basis for a finding of legal impossibility. For the reasons Rob stated, I'm not sure that a tenant would be successful on any impossibility doctrine, but it does appear to be, depending on if they are movie theaters or bars or some of those commercial tenants who have not been allowed to reopen, at least in North Carolina, or maybe have been reopened at a smaller capacity. That could be a defense that they may have to the repayment of rent or a reduced rent, something like that. The second would be the frustration of purpose doctrine or commercial frustration, which is very similar, and it essentially is when changed conditions supervening during the term of the contract operate as a defense to excuse further performance. Again, there have not been any courts in North Carolina that have interpreted this to allow a tenant not to pay rent for those purposes. But during this time frame, I do believe it would be something that a tenant may try as a common law defense, even if the same is not written into their commercial lease. So with that, I'm going to turn it over briefly to William, who will discuss what we have seen as bankruptcy coming out of some of the summary ejectment and lease dispute cases.
Thank you, Whitfield. I have not seen a spike in business bankruptcies since the COVID situation arose. Somewhat surprisingly, the prognosticators say that it's coming, that there's a little bit of a delay, and that it's coming, but we'll see. We'll see what happens. The filings I have seen were generally of companies that were already kind of on a downturn and had one foot out the door already, and the COVID situation has sort of killed them. But if a tenant files bankruptcy, it's not the worst thing in the world for a landlord. In this COVID situation or without it, there haven't been any increased protections imposed by bankruptcy courts due to COVID. If you, as quite often happens, if you go and on the eve of the summary ejectment and your tenant files bankruptcy, an automatic stay will come into effect. That's not related to COVID. That's always been the law and will continue to be the law. The important thing is once a tenant files bankruptcy, you as landlord need to stop all efforts to evict that tenant through court process, through self-help process, through sending letters, demand letters. You can't do that. The courts will punish violations of the stay. On the other hand, a tenant must assume or reject your lease in bankruptcy fairly quickly. And I say fairly quickly, certainly over some number of months. But if they assume your lease, then they have to assume the lease as it's written. They can't make modifications to it. They can't reduce the rent, force the landlord to take reduced rent, extend the term, that kind of thing. They also must cure all defaults under the lease, including pre-petition defaults. So the landlord is taken care of somewhat there. If the tenant rejects the lease, they still have to pay the full rent after the filing date, and that is classified as an administrative expense, which generally gets paid, as opposed to a general unsecured claim that generally gets paid cents on the dollar. The lawyers get paid the same. The lawyers get paid under the administrative expense priority. So that should give you some indication that if you have an administrative expense priority claim, you're going to get that. So if the tenant deems to reject the lease, their incentive is to get out pretty fast, because they want to stop those administrative claims. So anyway, thank you. That's all we have on the bankruptcy angle. Whitfield, I believe that concludes the program.
I believe so. I think Alan's going to speak.
Thank you, William, Whitfield, and Rob, and thank you everyone for attending today's webinar. Again, if you have any questions regarding the information presented, please feel free to contact us, and we'll be happy to discuss them with you. On behalf of Manning Fulton, have a fantastic day.